Hello, it is a distinguished pleasure to have you all today to discuss international perspectives on commercial mediation. This webinar is promoted by the Brazilian branch of the International Law Association, and as a member of ILA in Brazil, it is an honor to welcome some distinguished members of the international mediation community. Deborah Masucci is a full-time arbitrator and mediator. She's on the American Arbitration Association Commercial, Large and Complex, International Employment Panels, the American Health Lawyers Association Arbitration and Mediation Panels, Resolute Systems Panel, the Fair Claims Arbitration Panel, and she's also a fellow of the Chartered Institute of Arbitrators and member of the International Arbitration Club of New York. Gary Bimberg is a mediator, arbitrator, and negotiation facilitator, specialized in cross-border commercial cases, including matters involving insurance, reinsurance, aviation, sports, entertainment, and art. A fellow of the Chartered Institute of Arbitrators and a court-certified mediator, he has completed hundreds of cases with aggregate value of billions of euros. Gary is associated with GEMS and affiliated with, or has worked on cases administered by some 15 other institutions, including the Court of Arbitration for Art, the Center of Arbitration and Mediation of the Brazil-Canada Chamber of Commerce, ICC, and ICDR. And finally, Diego Faleck is a business mediator and holds an LLM from Harvard University and a PhD from the University of São Paulo. Diego is also an adjunct professor at Pepperdine Law and has acted as a distinguished mediator in high-level Brazilian and international cases. He's also certified by the International Mediation Institute. Our panelists and I have agreed to do this discussion as a roundtable, and as such, I will act as a moderator, bringing questions to the participants. And I also encourage in this context that our audience make their own questions to foster the debate with our invited members. So I would like to make
Oh my, this isn't good. We've lost our moderator.
Yes.
Well, for those of you who are on live streaming, we indeed have lost our moderator. Please stand by. Don't become impatient. Perhaps many of you know that part of the function of mediators is to make sure that people remain in the conversation. So please don't leave.
Well, Gary and Diego, maybe, since we know that some of the questions that Henrique was going to ask, why don't I just go ahead and start talking about the Singapore Convention and, how it will promote mediation worldwide. But more important, what I was going to address is how the Singapore Convention developed. And what it means to the international community. I was very honored to be part of the delegation that was sent by the International Mediation Institute to UNTITLE's Working Group 2, which was responsible for developing and launching the Singapore Convention. IMI was an active observer. And what does that mean? People who actually vote, or the entities who actually vote on any resolution that Working Group 2 came up with are the member states. However, they're constantly looking for information. And while IMI has a position about the usefulness of mediation on a domestic and international stage, we saw that this was an opportunity to promote mediation worldwide because there was a need for it. What IMI did initially was provide surveys that indicated that there was an interest in this tool, especially needed because many of the delegates indicated that there was no need for an instrument to enforce mediated settlements. They said there was no evidence that people were walking away from cross-border mediated settlements. IMI served, therefore, as the voice of the user. Many global corporations who did business around the world were finding that they any mention of mediation was resisted because people would say, well, we're used to arbitration. We know it can get enforced under the New York Convention. Why do we need mediation? There's no evidence that people are walking away. But this whole theme of if we needed an instrument to enforce mediated settlements to convince the counterparty to actually attempt to mediate. And that became a growing theme. Throughout the discussion, and I believe it was 2.5 years of discussions, might have even been longer, there was a big shift in the composition of the member state delegations. What we saw in the beginning was that the delegations were primarily composed of people who arbitrated, and they brought their arbitration hats to the table. So they were more focused on rules, regulations, procedures, and you can see a bit of protection of the arbitration area. Well, what happened was, little by little, the delegation started to change their composition, and instead of being arbitration oriented, a lot of them ended up having mediators as part of their delegations, recognizing that in their individual member states, they weren't mediating. So they started to see the advantage of expanding their mediation experience outside of the domestic into cross-border. And that was, again, pivotal because it changed the conversation itself. The chair of the working group was a woman named Natalie. She was from Singapore, and she really served the role of a multi-party mediator. She kept the groups on task. She was able to paraphrase and reformulate any consensus that was decided, and she created consultative sessions where everybody would go into groups to discuss, what they should do next. A lot of the literature, in fact, I wrote an article about it, talked about one of the pivotal sessions where there was a great breakthrough. And it happened in February in New York City. There was a snowstorm, and it was a big snowstorm, one where the whole city closed down. And the delegates were still there, but the UN was closed. So we had no place to meet. So delegates formed smaller groups and met in hotels, law firm offices, and other places. And as they met in these smaller groups, headway was made. And a lot of the barriers to moving on the convention fell away. And that led to a momentum that created the final convention. I just want to mention one particular section that was a stumbling block. We as mediators know and understand that a mediator does not sign a mediated settlement. They're not parties to the mediated settlement. However, there was a desire by many of the member states to have some mechanism that would demonstrate and validate that the mediated settlement actually was a result of a mediation. So a provision was put in place that the settlement needed to be signed by all the parties, and that there should be evidence that the document resulted from mediation. And that evidence could be a signature of the mediator, not as a party, but acknowledging that it was coming from a mediated settlement, or a separate document from the mediator, or if this was accomplished under an ADR provider's processes, they would have an affirmation. And there are other ways that it's done. This also made the regulation or the convention more compatible with some member states' own provisions, which required that the mediator notarize their signature on a mediated settlement. So in some domestic mediation, especially in the court systems, there were formalities which required the mediator to sign. So it made people much more comfortable with the document. So today, there are over 51 member states throughout the world who have signed onto the Singapore Convention, which was astounding. This was a major accomplishment because it took many years for people to sign on to the New York Convention. We do have, I believe it's 6 signatories who have ratified the Singapore Convention, which made it operational once three member states signed it. So it is in full force and effect, but we're continually working to get other member states, countries to sign on. Here in the United States, the convention is going to be considered by the Uniform Laws Commission. And that's a natural extension to how laws are adopted in the United States. And Uniform Laws Convention will then make a recommendation to the government to go forward and sign the convention. I am part of that discussion also. So hopefully the United States will not be too far behind in terms of signing or ratifying the convention. It was an exciting few years. I'm glad I was part of it. I'm honored to be part of it. And I'm honored to really talk about how great this convention is, not only for mediation, but to propel mediation internationally in cross-border circumstances.
Thank you very much, Deborah, for sharing your initial views on the Singapore Convention and all the process that you witnessed within UNCITRAL and as a member of the IMI. So I'd like to pass on, Gary. The topic of our conversation is international mediation itself. So I'd like to start with this distinction that the Singapore Convention brings, but it was also a factual and actual distinction between international and national mediation. So how is your experience as an international mediation compared to your experience as a national mediator? Do you feel like there are differences with contexts, with cultures? How do you feel this difference in reality?
Great question, Henrique. And before I go to answer that, I want to thank you for the invitation here today. It's great being here with you, with Debbie and Diego. And I want to thank also the International Law Association, Carvalho, Machado, and Team, Advogados, and the CAMC-CPC. It's great to be here with you all today. So what was the question? No, I'm just joking. I see cross-border mediation as an elevation of the game. Game in a very figurative sense, I'm saying. The game that we have in domestic mediation. And I'll tell you what I mean by this. Whenever we're in a mediation, we have 2 or more parties who have a different viewpoint about something, whose fault the degradation of the business relationship is, who breached the contract. And they're dealing with the same set of facts, but they have different perspective on it. And those different perspectives inform the positions that they take. In order for a mediator to be able to create a fruitful conversation between, let's assume that there are two parties, but there could be more, but between two parties, he has to have a certain grasp of the perspective of each party on this. And the perspective of each party is going to have to do with the position that they had in the business relationship, assuming it's a commercial thing, and the loss that they incurred. So we're talking already about a certain diversity within the mediation conversation. Now we start considering other things. I'm still in the domestic realm. Now we start considering, well, okay, one of the parties is a multinational corporation that is being represented by an executive of that corporation. The other is the owner of a business that was doing business, but the owner of the business that's doing business, or that was doing business with a multinational, they have two completely different perspectives, particularly if you consider that the executive of the multinational has to answer to his board of directors, his or her board of directors, who has to answer to the shareholders. There's a totally different dynamic there. And the mediator has to approach each in a different way. And then let's assume, for the sake of argument, that, that we're talking about a diversity in education between the two parties, or the two party representatives who are in the room. Any diversity, even domestic diversity, within culture. Let's say that you've got on one side of the table somebody from the northeast of Brazil and another person in the south of Brazil. We're talking about different cultures. And then, so you start layering things on. But this is the food, this is the fuel that the mediator works with. So you already start with this sort of thing, with this, considering the different diversities, and then you layer on more and say one company, or the representative of one company in the mediation, is from one country, and the other is from a different one. So what do you have to consider there? There are a whole nother set of things that you have to consider, which actually some of them you could consider otherwise. What is the view of each party toward mediation? What is their definition of mediation? Particularly if you're talking about separate jurisdictions, mediation can mean something completely different in two different legal systems, let alone in two different cultures. Then you have to consider the individuals involved as well. And the certainly part of the mediator's work is to create some sort of connection, trust, empathy with each party. So when you're in an international or cross-border context with a diversity of nationality, you've got to consider in what different ways, what different tools are you going to use as a mediator to create that link with two people, or two or more people from different cultures. And I just want to bring up one quick example, which is, I think, encapsulates this whole thing to a certain extent. In the beginning of the last World Cup tournament, it was during the preliminary rounds, I had a mediation between a Brazilian and an American. Now, so the Brazilian obviously was following a seleção in the Copa, obviously, and who doesn't? Who doesn't? And I knew that had to be on the top of his mind. But that was for the American. The American, he was from southeastern Wisconsin. Now, most of Wisconsin, and particularly southeastern Wisconsin, some other parts of Wisconsin, are absolutely rabid fans of the American football team, the Green Bay Packers. Now, I originally came from, I was brought up in the neighbor state, Minnesota. Now, one might think that there is a huge rivalry between the team from Minnesota and the neighboring team from Green Bay, Wisconsin. And there is, but it's a friendly rivalry. So I went to the room in caucus with the Brazilian, and I started talking about a seleção. Well, we created a bond. Then I went with the American, with the guy from Wisconsin. And I said, you know, I'm from Minnesota. I'm a Vikings fan, but boy, those Packers had a great year last year. And we created a bond. So you have to look in different places for how you're going to create a connection with each of the parties when they're from a diversity of jurisdictions, of nationalities. But sometimes you can find that in a sort of a common language, football, football, soccer, whatever it is. You know, you look for that, you find it, you use it.
That's great, Gary. And it's very interesting that you bring the relevance of such connections as an American with experience abroad, especially in Brazil. And now we can pass on to Diego, which goes the other way. He's a Brazilian with international experience, especially in the United States. So Diego, how can you address this problem of cultural differences within international mediation?
Well, thank you, Henrique, for first, thank you for the kind invitation for this event. Well, I think it all starts with an old discussion. Me being a Harvard alumni, and Harvard kind of the source of this modern dispute resolution theory. It's not only about Roger Fisher. It's 100 years older with Mary Parker Foyer. So it's been a long run where those concepts have been developed, and we have this discussion in the ICC Mediation Week, I think 10 years ago, about is this theory that was better organized in America, does this work everywhere else in the world, or is this an American feature? I always been a supporter that an interest is an interest in Brazil, in China, in anywhere else. A position is a position, and Batna is a Batna, and you can go further. How those concepts apply, in my view, they are beneath the level of culture, gender, or whatever. So I think that this irresistible modern theory and practice has been developed underneath the culture level. There are people that differ. I don't see how, but there are even tweaks. For example, if you talk about body language, most of the Western culture would say that, for example, it's a good practice to look in the eye, but maybe it doesn't work the same elsewhere. So there are tweaks that you have to, but I would say that if you work with, modern business, Western standards, I think that you can be pretty safe that all the theoretical background you have is great for preparation and for dealing with culture. I mean, there's a lot you can do which is beneath culture. That's my first. So I learned in the United States and I came back to Brazil, and even in domestic Brazilian cases, I've applied those techniques, and that has been kind of a source of success, in solving very, very difficult cases, not only in mediation, but in dispute systems design for crisis and so that's my first thing. I think that, and of course, the many different places in the world have been studying and developing and adding to the theory. But we must recognize, well, the source of everything, which is in the United States. So that's one thing. Another thing that I would say about cultural difference, I think, as Gary mentioned, even in Brazil, it's a huge country, so we have different cultures. Even in different markets, you have different cultures. If you go, for example, to reinsurance, they're very developed. They do like the dance of numbers like anyone. If you go to, I don't know, different markets, retailers, for example, people have very low margins, so they're very tough. Construction, I mean, each business has this. So when you talk about culture, it's not only about different countries, but what I think is you need to be able. In my view, I think culture requires an extra level of empathy. You have to really understand someone who's very different. So you have to understand the person. You have to understand the patterns. There are, when you talk about patterns, you can lose you can miss the target, because you go to stereotypes and stuff. They work to some extent, they don't to another. So that's kind of something you have to take care of. For example, you can say Brazilians are emotional. There's research saying that. I don't know, Spanish, they kind of burst very easily. So you have those stereotypes that you have to deal with. Italians, they move too much. So, there's those things there. Some of them are funny, but the French, they take a long time trusting you, but when they trust you, they become. So you have all those things that you have to pay attention. You cannot follow through stereotypes, but you have to capture patterns, read people, and one of the things that I think helped me a lot was being exposed. Not only I've done an LLM in the United States. You have people from all over the world, so you get exposed to different people. We work in international events. Like we go every year to Paris to the ICC mediation competition, and we talk a lot and we discuss things. We work on international cases. So I think learning how to see different people, see how they work, and I think this extra layer of empathy makes you a better mediator to deal with the international. So just to sum up, I think we all in the world owe a lot to the United States in this field, the modern field. I think it's something, you talk about culture. I think there's an issue about civil law and common law, and how clearly mediation suits better. I know it's easier to understand if you have a common law head. So that's one big issue. So we owe a lot, and I think that it can be used everywhere else in the world, and I think it's a lot about being truly empathic and understanding. I have, just like Gary said, I have one example. I once was mediating, and I don't know, for some reason, I think I have a more Anglo mind, being a Brazilian. So that's an advantage, I think, for me, because I have the Brazilian understanding, but some sort of a different way to see law and everything. And it's not only about mediation. I think it's about every field of law. You have influences from, law and economics and the regulatory system. So we have to be open. And I was once mediating a case between, was a reinsurance case. You had the British reinsurers and the Brazilians. And it was a huge claim. It was a $700 million claim. And then there was this adjustment report from the British steering committee that we were supposed to have a round in Brazil to discuss. And the adjustments report just said there was no losses, basically. So we had a meeting in Brazil. We were having the team of this huge Brazilian company, and and then we had this meeting, and I had caucus with the British, and they say, okay, so we need to ground this discussion somewhere. We have an adjustment report for the losses, and we would like to start by that, but we would like to have them criticize our work. And then I came back to the other room. There were the Brazilians, and then they said, so how do you think about starting like criticizing their work? So we didn't read the report. So you didn't read the, no, we read the last page. It says 0. I'm not going to waste my time. So I came back to the British and said, oh, they didn't read the reports. What? This is like a joke. This is like we were catching a plane, we're leaving and everything. I said, no, this is a culture. They read the last page. They thought it was a waste of time. They were really emotional about the whole thing. They disregarded it. And you know, this was just a sample, but they need to. So we had there like a cultural issue. So in the British side, they needed to ground the discussion on something. Every dime needed to be justified. And the Brazilians, they were more emotional. This doesn't work. I'm not buying this thing. And so that was a very difficult case. But one of the things was my first challenge was to explain to the British that there was no ill fate. There was no, that they were committed to the process, but they just have a different way to see how things should go. So it's difficult sometimes, but you have to be able to communicate between different worlds.
So
Exactly.
Henrique, if I may, I think that what we're seeing is both Gary and Diego borrowing from their American experience and really capitalizing that American experience, whether they lived in the United States or went to school in the United States, to really address cultural issues and cultural differences. You know, I heard Diego say a few times that we have to thank the United States, and you know, it's wonderful what the United States is doing. I have to hold people back in the United States because a lot of people in the United States think that their way to mediate is the only way. And when they mediate with people of different cultures, they force their values onto that mediation without taking the time to understand the different hierarchical decision-making or the different timing modes. You know, somebody in one culture may have a thought process where they're accepting of proposals later on. Diego now talked about civil law versus common law country. Well, depending on which rules or which laws you come from, your BATNA is going to be very different. So, you know, somebody who comes from a common law orientation, when they're with people who are in a civil law orientation, their risk assessment is totally different. So the mediator has to really understand and evaluate that in a different way. The International Mediation Institute has a cross-cultural certification. And one of the standards in that cross-culturation is that an international mediator first must understand their own cultural orientations and prejudices and biases. And then once you understand yours, you can then apply it to the parties who you're dealing with. But I don't want to overlook something that Gary said from the beginning. You need to have not only empathy, but you need to build a rapport and find a bridge between the mediator and the parties. And it may be different in each room. And that develops the trust in the mediator to really help the parties move forward.
That's great. So, yeah. So to sum it up, I mean, I believe we were building like a common technique, but not necessarily a common culture. It's a common technique to address this variety of cultures. And Gary, you would respond to Deborah right now, and if you can like If you feel that if this is what I just said is contradictory or not, perhaps you can address it also.
Well, yeah. First of all, I endorse everything that Deborah said and that Diego said. Really valuable input altogether. One aspect that we that we haven't addressed yet that I'd like to throw on the table, if I may, is this question of what is mediation and what people from different jurisdictions interpret mediation to be. And I will tell you, I think that this story that I'm going to tell, it's a very short one, encapsulates it absolutely perfectly. I was speaking with a professional, a Chinese professional in Shanghai about 10 days ago, prepping for another webinar. And the webinar had to do with style of mediation, and he asked me to describe to him evaluative mediation. So I made the explanation. I spoke about, I wasn't brutal about it. I spoke about the mediator really taking the lead, perhaps using specific references that he or she generates as something that the parties could aim toward. And once I finished with my explanation, which was a bit more detailed than that, he said, "Oh, you're talking about Chinese mediation." And I thought that was absolutely brilliant. That was absolutely brilliant as a commentary, because it tells us so much about our different, what our different expectations can be. And in the United States, we have a great duality in which we've got these seats of thought, like Diego's Harvard and Diego's Pepperdine, great institutions that are really thought leaders globally in dispute resolution. But we've got this practice in the United States, which on a day in, day out diet, not 100% of what happens in the United States, but I would say that the majority of attorneys who arrive with their clients for commercial mediation expect not what they're talking about in Harvard or Pepperdine, they're expecting some form of evaluative mediation, which is absolutely in contradistinction of what we perhaps consider to be best practice. But it's their expectation. When we arrive there, we have to deal with that expectation, even if we want to modify the process that we're in from what that expectation might be, particularly in the case where there might be a diversity of expectations. Just one other angle to this: Brazil mediation is well, perhaps I was going to say in its infancy, but it's perhaps a little bit older than that. It's a toddler. It's it's starting to walk. It's testing out running in Brazil now, and but there's absolutely a feeling that facilitative mediation is what mediation is, and anything other than that is something other than mediation. Okay, there's some schools of thought, even coming out of Brazil, which say that there's the transformative, which is just as valid. But I would say the mainstream and what's being taught essentially in Brazil is facilitative. And to the extent that Brazilians are familiar with mediation, this is what Brazilians will expect out of a mediation. And again, if you have a Chinese party with a Brazilian party, you're going to have very different expectations of how the session will be conducted, and the mediator has to adapt to that.
Excellent. Diego, do you want to jump in with regards to these expectations varying across?
I do agree. I think that this example that Gary took out, the styles of mediation, I have been criticized in Brazil as some sort of wolf of mediation, because I am more, I wouldn't say I'm evaluative, but I am pro-business, let's say. And this becomes a philosophical debate, and the few people that are thriving in the market are the ones who are more open-minded and connected to what is happening elsewhere in the world. There's a large I think there's something in Brazil which is what people have been discussing and teaching and what is happening so in business. So there's a kind of a, but there's one thing that we do in Brazil, which is dealing with mass disasters. That's is one thing that we've learned from the United States, and because of our different reality, we have to adapt. We've seen the many big names as Ken Feinberg, Francis McGovern, Eric Green, the people who have been doing those mass claims, dispute resolution systems for decades. Some of them already passed. And they had a different system that it was more like a special master. It's like a master arbitrator within and in Brazil, we had to develop a different scheme that is working in such cases as Brumadinho, as a huge case in Maceió, currently thousands of people. We've developed a mediation scheme where we have a basic a process with transparency, objective criteria, and everything that we learned, but we use mediation and the parties negotiate. So we've adapted some of, so it's something that you can say like dispute systems designed for mass tragedies is something of the American feature. I think we've done something in Brazil which is different, and it's very effective, and in some ways I can even claim more humane is a strong word, but more connected with procedural justice and more empathic, let's say. And those are things that they're not happening anywhere else in the world. You can see the big fire in the UK. They haven't set up any quite similar system. I have worked with the Air France accident. There were 52 nationalities involved. I can say that France was in Germany. We're all watching what we were doing and trying to catch up. We've devised a dispute resolution system. So I can say we learned from the United States. There are some developments that we can make, and I think we have made in Brazil. And I think that, and that's one thing. I mean, in Brazil, we are, I think, and I can hear, I think Gary has this experience of Brazil, this strong experience of Brazil. In Brazil, we are somehow humble, and we are somehow open. Even they say that, companies like in the beauty market, they test new products in Brazil because Brazilians are open. They use different things. So we are actually open. Sometimes in Europe, when you have more developed nations in other ways, they're kind of skeptic. They think they're doing the right thing already, and probably they're not. In Brazil, since we have this kind of underdog feeling, we are open to getting better. So I think all this counts in terms of developing, bringing the game to another level. So I think Brazil being a country where you have ridiculous litigation statistics is a fertile field for developing new things. So I think that's the role we play. And we drank from the United States, and I of course I've expressed how thankful I am, and I think we all should be. On the other hand, I think that we don't need to catch up. We need to move forward. It's not only about catching up; it's about moving forward.
So Henrique, one of the next questions that you posed with us has to do with, is there any particular change in attitude towards mediation globally? And a number of years ago, the International Mediation Institute launched what's called the Global Town Conference, because there was this view that mediation was stalled. That everybody was an acolyte talking about mediation, but we weren't doing it. So the goal of the Global Town Conference was to go out in the world and have conversations throughout the world and find out what the expectations of the stakeholders were for mediation and what the future of the mediation would be. One of the outputs was that there was an interest in what is now being called mixed mode. You know, to a large extent, up until the Global Town Conference, people were purists. They were either mediators or they were arbitrators, and never the twain should meet. And an arbitrator could refer a matter to another person to serve as a mediator, but that arbitrator would never serve as a mediator themselves, unless there was a list of disclosures that had to be made. Well, we found that there is a lot more mixing of processes that is going on around the world than we even recognized. And that formed a task force of Pepperdine, the College of Commercial Arbitrators, and the International Mediation Institute, called the Mixed Mode Task Force. And they formed 7 groups in their papers in September to create a conversation about whether the paper's on the right track or the wrong track. The goal was that stakeholders to use, and they're not going to be theoretical. These are practical tools for the stakeholders to use ongoing, you know.
I think she's experiencing a problem in the connection.
Looks that way.
Yeah.
I can make a couple of comments if it's appropriate. Are you back, Debbie? No, it doesn't look that way. Shall I make a couple of comments? Henrique?
Please, I think you can begin with your comments. So when she gets back, we bring her to the discussion.
Debbie is going into an extremely interesting area here, and it's something which the genesis of it predated the talk of the Singapore Convention itself, or predated the UNCITRAL working groups. And this is the idea of somehow taking advantages of mediation and arbitration and mixing them together one way or another. And there are 2 aspects to that. There's a formality of it, in which you start an arbitration process and then can go into mediation. Contractual constraints and best practices have some limitations on how you navigate that transition, and particularly the transition back to arbitration if mediation is not successful in terms of resolving the entire conflict. Now, that's the macro view of it, but the other aspects, which Debbie was just starting to touch on a bit, is when you're in a mixed mode setting, and start with arbitration, go into mediation. When you're in mediation, if you don't settle the whole thing, you might be able to sort out some aspects of it. You might be able to sort out half of it. You might be able to come to an agreement on a certain portion of the discrete issues that are being dealt with in arbitration. So, this is pulverizing it a bit more and using the techniques in a complementary style without being absolutist about it. The next step, though, which also is really interesting, is using techniques of an arbitrator using mediation techniques in arbitration session. Oh, for instance, one thing that I like to do, I'm a dual practitioner. I'm both an arbitrator and a mediator. If there's a dispute on an issue within arbitration, and the parties come to me and they say, we'd like to brief this issue for you to make in the form of a motion, whatever it might be, in order for you to make a determination on that. My first reaction is, no, let's do it the following way. You two have 1 week to try to sort this out between the two of you. If you haven't sorted it out, well, even if you have, we're going to come back and we have a date scheduled 1 week from now, in which we're going to talk about it. And the three of us together are going to try to sort it out. Now, I'm not telling them that I'm going to be acting as a mediator in that conference 1 week from now. But as to all the issues which aren't resolved, I will be working as a mediator. And that is a fantastic play for efficiency within the arbitral process, which is just, and for me, this whole idea of how we can leverage one against one off the other and make the process of dispute resolution more efficient, more dependable, and more viable by taking aspects of different disciplines. I think that it's beautiful. Secondly, I think it's the future. And in a way, I'm going to riff off of what Diego said a few minutes ago. The approach that Brazil is taking to dispute resolution and mediation in particular these days is reflective of the adaptation of best practices, an awareness and curiosity of high-level thought and academic work on the topic, which can lead Brazil to be, not just in mass tort cases or other cases, but in general, one of the leaders in the world in mediation. And it has to do with the character of the Brazilian people, openness to innovation, as Diego said, and willingness to embrace new ideas, and also with a lack of galvanized thought about what mediation must be, might be, and more about what it can be.
Just picking up on what Gary said, about the mixed modes, I think Deborah's back.
Yeah.
There she is.
Sorry, I was
missed you.
I got lost mid-sentence, so I'm going to have to recreate it. But Diego, keep on going because I heard you were talking about it.
Yeah, I was just mentioning about the mixed modes that you brought up, and Gary added some thoughts to it. I see there has been there's one way that I see that is moving forward in terms of making tangible this interplay between mediation and arbitration. And one of the things that I've seen the CPR is proposing, they have some clauses about concurrent mediation and arbitration, which is about having a mediator from the outset, following up with the whole arbitration process and finding the room for partial settlement, and just involve a mediator from the outset. That's one way. There's another way that we have been discussing, and I am particularly working on drafting some clauses. Edna Sussman has been working on the topic, is the issue of mediation windows, which I think that the idea of, in my view, and I would like to see Gary's and Deborah's views on that, to hire a mediator from the outset, and to be open for a concurrent mediation, you have to be so lucid and strategic that I doubt even the United States is there already. I think very few people would be as open-hearted and, convinced of doing this. I think, I don't think it's something very common. And I think that one of the greatest problems is when you try mediation. Mediation, maybe in the beginning, parties are not ripe. Sometimes it doesn't work. The anger is still fresh. The hopes that, that you can settle are low because you just had a bad experience. So rationally putting mediation in the beginning makes sense because you resolve the problem more there, you spend less, but in practice, it doesn't work because of cognitive biases and because we are not perfect rational people. But then what I think is you should kind of find checkpoints in the arbitration procedure where you have a safe face for parties to go to mediation. And that's what we call a mediation window. You find a space where parties will discuss. You all you have to do is put clauses like, after this stage of arbitration, we are bound to sit and discuss. So then you would have a safe face for parties because nobody wants to give in. Nobody wants to take the first step towards amicable discussions. So I think, in dealing with real life cognitive biases, I think we can think more about this idea of putting those checkpoints to discuss, to allow for mediation windows than I'm thinking on, perfect, more rational scenarios that I think are more rare. So I just give back the word and eager to hear your thoughts.
So there, when we did the task force, one of the things we talked about was that mediators themselves, they're mediating every day. So they've seen a lot of the permutations and the opportunities. But parties only have a set of cases. Now, Henrique didn't mention it, but I worked for a major financial institution for many years, and for 10 years. And our corporate portfolio of cases that could go to mediation was very finite. It was an insurance company, so our claims organization had loads of mediation experience. So it's unusual for a user to have that type of experience, but they also still use one tool. So the concept of guided choice came about, and Paul Laurie is the person who really developed it as a mediator being engaged early on to not necessarily serve as a mediator, but to talk to the parties about their different options that they could use. And Diego actually raised one of the options that could be discussed, having these mediation, windows. So, it's really interesting how there are these offshoots that are coming about through thinking. One of the members of the task force is a mediator from Switzerland, Jeremy Lack. And I always think that Jeremy is pushing the envelope all the time. Like I know
He
you're
is.
he is pushing the envelope. And, he was on the task force or the working group that I co-chaired, which is on communications between mediators and arbitrators who are appointed to the same dispute. Whether they could communicate to each other, under what terms and conditions, and what should they be communicating to each other. Because even the members of that task force were basically saying, I can't, as an arbitrator, I can't hear from the mediator. That mediator may influence my decision-making process. And the mediator basically saying, I can't hear from the arbitrator. They may influence me too. So the answer really is they should be influencing each other, but under what terms and how? And that may be too futuristic for our current environment, but it may be something we're going to be doing in the future. So, Go ahead, Gary.
Yeah, I think that we're edging into that world these days. We're talking more and more about that. I think that it's part of the conversation that was started with DuPont and whenever it was a few decades ago. It was CPR, which has been mentioned before, and which awarded to Debbie a very well-deserved honor in 2020, was instrumental in putting this on the agenda. It's now it's created two versions of a pledge. The current one is now the 21st Century Pledge, which in essence, companies, they excuse me, I've got my phone's ringing, I'm silencing it. My apologies. Companies sign on to it and pledge to use alternative dispute resolution as the first line of attack. Or attack is an unfortunate terminology for this, but as the first option in dispute resolution rather than litigation. And also, I should mention that Dr. Kazuo Watanabe has done something similar in conjunction with CSP, Fiesp in Sao Paulo, in establishing this sort of pledge. And this reminds us that what, as a legal community, we need to do is support the interests of our clients. What are the interests of our clients? It's not to go out and to litigate. It's to find the most efficient, effective, and interest-rich ways to resolve their problems and their disputes. And then comes the question, what is that? How is that? We know that mediation is extremely efficient and extremely cost-effective, but you can't settle everything in mediation. Now, my position with regard to this is, if not formal mediation, then something that looks like mediation needs to be integrated. It needs to be integrated into whatever processes we use, be it arbitration. And by the way, JAMS has part of its rules the concept of an option of having a standby mediator accompanying arbitrations that are administered by JAMS, which I think is part of the puzzle. But the whole concept of the puzzle is doing what's best for the client. And doing what's best for the client is to let the client do its business, whether it be producing chemicals or silicon chips or whatever it might be. It's not to be mired in litigation. It's to get out of these problems and move forward.
But Gary, we can't forget one important aspect. The objective of a client may not be to get back to business. It may be to exert as much pain to the other side as possible. So, that's one thing mediators have to, and dispute resolvers have to understand. Our goal, our value is to let the corporations get back to business, but some businesses, that's not their goal. So we have to understand what the objectives of the parties are early on so that we can play to that and resolve the case or help them resolve the case, acknowledging those goals.
I take just the slightest, here I'm being a lawyer and I'm being very semantic. I would make a differentiation between objective and goal and saying short-term objective, long-term goal. But you're right.
I accept that.
Okay, Diego, we actually have a question from the audience, but I would ask if you want to address a final remark, and then we can go to the questions from the audience.
No, I think feel free to get the
okay.
question.
We actually have. I would like to thank especially some students have have graded you, Ana Fonseca and João Victor Maciel. And Ana has a question which I would like to bring to the table, which is, considering that the enforcement of mediation agreements is still an issue, what are the main challenges for the Singapore Convention to be globally accepted? So Deborah, perhaps we can start with you and go around the table.
I think that there's been a few impediments. The European Union has been a big impediment to the Singapore Convention. They were very, very active and constructive in developing the provisions, but now they're struggling with ensuring that the Singapore Convention does not conflict with the mediation directives of the EU. So there's now this tossing back and forth. On the other hand, there are countries in Eastern Europe who have already ratified the Singapore Convention. I think that we're going to see more buy-in in Asia much more quickly, and more buy-in in Africa much more quickly than in Europe. And that may be because in the African countries and in Southeast Asia, there's more business opportunity. And you have Singapore who's pushing it very dramatically. So I think there are different challenges, but I think that's where you're going to really see a lot of movement.
Great.
Yet, in my mediations, I haven't seen a challenge of enforcement ever. I mean, maybe I'd like to hear Deborah and Gary, but I think my humble view is that I'm a full-time mediator. I'm not an arbitrator, and I'm not a lawyer. I have a law degree, but I'm not a lawyer. I don't work as a lawyer. I think that the Singapore Convention and discussion, they take the approach of the lawyer to the mediation, like not being so optimistic about it's the nature of the lawyer not to be optimistic about things. What would you do if things if someone doesn't want to abide for the agreement? But I think the very nature of the mediation is, as parties build the agreement together and parties come up with a solution. And I would like to look into the statistics. I think it may vary from country to country. I think the Asian countries, they have a different legal system, and then probably you need more clarity. But I don't want to interrupt you, but I think what's really well, first of all, that was one of the resistance points to even developing a Singapore Convention. There was no evidence that people were walking away from mediated settlements. But corporations felt that they weren't getting enough people into mediation because they were saying there is no enforcement mechanism. Just think about Singapore developed a process called ARB-MED-ARB, so that a matter had to be filed in arbitration, but the parties mediated, and then they could go back to arbitration to get a consent decree that could be enforced under the New York Convention. So, there's a lot of this stretching and trying to put a round peg into a square hole to make mediation work. So now the Singapore Convention, you don't have to go through that process, which let's face it, costs time and money, to go ARB-MED-ARB. So I think that it creates more of buy-in for the process. And then the other area where we're seeing some movement where we did not see it before was in investor state. You're seeing more and more investor state cases that are being mediated, not a cavalcade. It's not not an eruption, but it's happening more and more. So as states view that, and big investors on multi-million-dollar deals view mediation as helpful, and probably more in the mixed mode attitude, you're going to see mediation propelled and the Singapore Convention used.
If I could just take a little thread from each of Debbie and Diego, and initially, I believe that the Singapore Convention, the proposal of the Singapore Convention, or what became the Singapore Convention, was a solution chasing a problem. That there wasn't use for it. But the more that we get into this, the more that I hear of the talk of mediation among arbitrators, among litigators. Mediation is starting to convince what previously was a skeptical public, who at times were controllers of the gates to dispute resolution, the legal community in general, and businesses, for the simple fact that it could be, and the settlement could be enforced. Many people were previously looked at mediation as being a light version of, not a serious, not without the gravity of arbitration and litigation, simply because, well, for two reasons. One is because you talk a lot. Second one is because there's the requirement of coming to an agreement. There was a certain latent taint of it being very successful in family disputes, which is true, it's very successful, but that doesn't mean that it's not going to be successful in other contexts as well. It's extremely successful. But once we're able to step back and look at mediation, shed the spotlight on it, then arbitrators started being interested in it. The gates are opening. I think we're moving into a new era in which mediation takes a much more front edge profile in the panoply of dispute resolution.
I do agree, and I think the Singapore Convention is a great thing, and it's very helpful. And because of the reasons you outlined, I just don't think there is a enforcement problem, and that's my point. But maybe this is good to say, because we will continue to do mediation with Europe, and I don't think there will be an enforcement problem. And I think it makes sense, because since the audience are lawyers and gatekeepers, internal counsels, and the gatekeepers are lawyers, you should speak their language. You should give them comfort. And I thought it was great. But that's my point.
That's excellent. I mean, to draw from all your remarks, especially about the Singapore Convention, we can argue that at least it creates incentives for for more mediations to come. And even within an economic analysis of law, this could be said to be a structural change to bring some relief, as Deborah put it, to the actors, to the players. And when I first came to this subject, which is international mediation, and now I'm going to our closing remarks due to our hours, but just when I first came to this subject, back in 2018, it was exactly when the Untitled was making their final draft of what would be the Singapore Convention. And as an international lawyer, and specifically studying at that time private international law, conflicts of laws, it came to my attention that the Singapore Convention, Diego, specifically with regard to the Brazilian law, could help prevent some problems for this enforcement. It's not like the problem of the enforcement exists, as you point out, but it could be an incentive, as Deborah points out, or it could be a solution that we perhaps did not need, as Gary pointed out, but it's welcome regardless. So when I first came to this subject, as I said, researching private international law, my goal, my main preoccupation was to solve a problem of private international law, which is qualification or characterization. I mean, to use one word to describe an international experience, an experience where I can have parties from the United States and from Brazil as we have now. So to close our panel, thinking of a qualification for our panel, which is an international subject, I would describe as inspiring. It has been inspiring to hear the three of you and to hear the experience, the huge experience each of you have in a specific market, in a specific sector. And it would be wonderful to spend, I think, the whole afternoon, especially because Deborah has and Gary have got 1 hour more than us, Diego, so perhaps they can stay a little longer. And it would be wonderful for us to stay here the whole afternoon. And but I think we have to come to an end. I believe that this is the first of many discussions that we could have virtually or in person. And I just right now extend my invitation not only to Diego, which is in São Paulo, but also to Deborah and Gary to come to Brazil and participate in our conferences and events when the circumstances allow. So it's been a pleasure to have you here this afternoon. I apologize for my connection instability in the beginning of our conversation, but I think that it did not prevent the success of your discussion. So thank you, Deborah. Thank you, Gary. Thank you, Diego. Thank you for the support team of the ILA, which is in the backstage helping us effectively with this conference. And I now want to hear your final remarks and wish you all a great day and a great week of work.
So let me start. Henrique, thank you so much for inviting me. And I really welcome continuing the conversation with Diego and Gary in the future. It's been a real pleasure, and it's really been exciting to hear their thoughts and really know that what we say is very compatible with each other. But thank you very much for inviting me with this esteemed group.
Please, Gary.
Gentleman as always, Diego. Not that you're not a gentle lady, Debbie. To the contrary, But I just want to echo Debbie's remarks. The thanks to you and Henrique and to the sponsors for being here today. I really enjoyed the conversation, and I think that if there's one thing that we can take away from this pandemic that's been very productive is the ability to gather people together from Sao Paulo, New York, and Miami simultaneously, so that we can have this sort of rich conversation. Love to come back, Henrique. It would be a pleasure, but I think that I have to make the qualification that I only want to come back if I can be on a panel again with Debbie and Diego. If not, I'm not so sure. No, I'm joking, but I very much enjoyed the interaction today. Thank you, both Debbie and Diego, and you, Henrique, as well.
Yeah. So thank you, Henrique, again, and the ILA team for this wonderful panel and for putting all the efforts you have put to structure this. And Deborah, Gary, it's a great pleasure to be with you here discussing those topics. Whenever, wherever, count on me.
Okay, so I think we're done here. Thank you all for coming to our conference, and we'll have another panel at 4 p.m. Brasilia time. See you there. Bye-bye.
Bye-bye.